one.
Okay, welcome everyone to the quarterfinals of the 10th Rio Pre-moot. It is a great pleasure to preside this panel today. I was kindly asked by my co-arbitrators to do so, and I humbly accept the role. So I'll be your presiding arbitrator today. First, I'll announce to those who don't know, we have a panel today between National Law Institute, University Bophal as the claimants in this hearing, and University of Cologne as the respondents in this hearing. So congratulations to both teams. You made it. You are among the best 8 of 50 universities from all around the world. This is not a small deed, so we are very excited to have the opportunity to hear you today. So first of all, I would like to please ask my co-arbitrators to introduce themselves to you, and I'll start with Professor José Gabriel Assis de Almeida, please.
Thank you very much, Mr. Chairperson. My name is José Gabriel Assis de Almeida. I am a law professor at Federal University of Rio de Janeiro, Unirio, and also a lawyer in Rio de Janeiro, and I welcome very warmly both teams, and I wish both teams lots of luck in this hearing.
Thank you, Professor. Now, please, Professor Greenbaum.
Thank you. Good morning from Rio de Janeiro. Again, congratulations to both teams. And I am a private international law professor at the University of the State of Rio de Janeiro. And I'm also the founding partner of Greenbaum Advocacia. But most importantly, and that's what gives me the greatest pleasure of my life, I am also for the past 11 years a coach for the Pre-moot to the teams of my university. So I do recognize and acknowledge all the hard effort that you both put into this. And I wish you all the best at the Rio Pre-moot and also in your future law careers.
Thank you, Daniel. And my name is Isabel Miranda. I'm also a coach for University of the State of Rio de Janeiro for the last 11 years. And for about the same time, I have been a lecturer in the same university of private international law and international commercial arbitration. So before I begin, I'd like to remind those who are watching on YouTube, if you are scheduled to meet either of these teams in the Pre-moot of Vienna or Hong Kong, you should not watch this video, okay? So now I will officially commence our hearing. We have Aisc proceedings number ADM 123/2021 in the matter between LGUP PLC as claimant and Jaja Biofuel Limited as respondent. Before we begin, I'd like to please ask counsel to introduce themselves, starting with counsel for claimant, please.
Greetings, everybody. My name is Bhavna Lakhina, and I'm from NLIU, National Law Institute, University, Bophal.
Greetings, everybody. My name is Raghav Srinivas. I'm also from NLIU. I'll be representing the claimant on the merits of its dispute.
Thank you. And now counsels for respondent.
My name is Nomi Hör, and I represent University of Cologne, and I will speak on the procedural issues on behalf of respondent.
My name is Joel Ola. I represent respondent in these proceedings. I represent the merits of this case.
Thank you, counsel. So before we begin, counsel have discussed among themselves about time allocation for this hearing. So to those who are watching, we are going to start with the jurisdictional issues. And on this issue, respondent will start for 40 minutes, followed by claimant for 40 minutes. And then we'll have 1 minute for rebuttals and surrebuttals. And then we'll go to the substantial issues, this time starting with claimant for 40 minutes, then respondents for 40 minutes as well, and 1 minute for rebuttals and surrebuttals. Could counsel just confirm that I got it right?
Yeah. Yes.
Yes.
Awesome. Thank you. So without further ado, let me get my watch ready. Just a second. I think we can begin then with counsel for respondent on the jurisdictional issues. The floor is yours.
Thank you, Madam Presiding Arbitrator. Honorable members of the Arbitral Tribunal, good afternoon from Cologne. Arbitration is a creature of contract. Accordingly, it is the parties' consent which is the key element of international arbitration. This ensures that no one is deprived of one's fundamental right to have disputes resolved by a national court unless and until one has deliberately and consciously agreed to do so. Accordingly, before an arbitral tribunal is empowered to hear a case, the parties must have concluded a valid arbitration agreement. However, it is respondent's submission that the parties never agreed to arbitrate. First, any arbitration agreement is not valid as to substance, and second, the pertinent form requirements for an arbitration agreement are not met. Turning to my first point, the substantive validity. In order to determine whether an arbitration agreement is valid as to substance, it must first be assessed which is the law governing this arbitration agreement. However, the parties are in dispute about this law. Whereas claimant deems the law of Danubia as the law of the seat as the applicable law, respondent submits that the law governing the arbitration agreement is Mediterranean law, which also governs the underlying contract. If I may direct the arbitral tribunal to page 32 of the record. Is the tribunal with me?
Yes.
On page 32, there are two versions of claimant's arbitration clause. The version on top was before the changes in 2016, and the version on the bottom after the changes. The arbitration clause at issue, which I will refer to from now on, is the arbitration clause at the bottom after the changes. Article 9, GCO's second line, contains a choice of the seat of arbitration, namely Danubia. In the fourth line, Article 9 contains a substantive choice of law clause, which determines that the substantive law is Danubian law. However, it is uncontested between the parties that the underlying contract should be governed by Mediterranean law and not Danubian law, and therefore this substantive choice of law clause is to be read as this contract shall be governed by the substantive law of Mediterraneo. Article 9, however, does not contain an explicit choice of the law governing the arbitration agreement. Therefore, the law of the seat, as well as the substantive law, could potentially apply. As per Rule 13.5 AISC arbitration rules, which are the arbitration rules applicable in these proceedings, the arbitral tribunal may determine, and I quote, the law governing the arbitration agreement in the absence of any agreement by the parties. Accordingly, it is first and foremost the party's choice of law, which determines which law applies to the arbitration agreement. This choice can be made explicitly as well as implicitly, and it is respondent submission that the parties implicitly chose the law of Mediterraneo to apply to the arbitration agreement. This implicit choice is demonstrated by 2 points. First, the wording of the arbitration clause, and second, the history of Article 9 GCOs. I now turn to the first point, the wording. Article 9, the substantive choice of law clause in Article 9, only confirms about this contract and does not differentiate between the underlying contract and the arbitration agreement, but refers to the parties' entire legal relationship. This is in line with the idea that for commercial parties, a contract is a contract. This idea was established by the Court of Appeals of England and Wales in the Sul-America decision in 2012 and recently affirmed by the UK Supreme Court in the case Anker versus Chubb, which was decided in 2020. Though respondent, of course, acknowledges that the arbitral tribunal is not bound by these decisions, they may serve as persuasive authority, as both courts were concerned with the exact same issue as we deal with in the present case, namely whether the law of the seat or the substantive law should apply to the arbitration agreement. And consequently, there was held that it can be presumed that the law governing the underlying contract extends to the arbitration agreement. In the present case, this is also emphasized by the history of Article 9 GCOs. As evident by the PO2, para 24 on page 51 of the record, claimant's general conditions of sale used to contain a separate substantive choice of law clause and a separate arbitration clause. However, in 2016, claimant decided to merge these clauses and consciously put the substantive choice of law clause into the arbitration clause instead of any other part of the contract. This action reveals an intent of the substantive choice of law clause to also extend to the arbitration agreement. And therefore, Mediterranean law is the law which governs the arbitration agreement.
So if I may briefly interrupt you there, I'm sorry. You mentioned about your last point about intent. You referred us to evidence that would show claimant's intent. Mm-hmm. But could you point also to any evidence of respondent's intent and any kind of meeting of the minds that would lead to this implicit choice? Because I assume that for there to be a choice, that must be both parties' intent and not just one of them.
Mm-hmm. Certainly, Mr. Arbitrator. On page 12 of the record, also respondent agreed on the fact that the sales contract, in para 5, it's the para which starts with following our discussion, in the third line, that the sales contract should be governed by the Mediterranean law. And as I pointed out earlier, for commercial parties, a contract is a contract, so they do not differentiate between an arbitration agreement and the underlying contract. And this email demonstrates respondent's intent to apply Mediterranean law to the entire legal relationship. And within the Mediterranean law, the conclusion of an arbitration agreement is determined by the rules which generally apply to the conclusion of any contract. These are the CISG and the Mediterranean Civil Code. The application of the CISG to an arbitration agreement is particularly preferable in cases where, as in the present case, also the underlying contract is governed by the CISG. In these cases, the application of the CISG to the arbitration agreement ensures conformity within the entire legal relationship and eliminates the risk.
I'm so sorry to interrupt you right again, but just to see if I fully understand your point. When you say that the CISG applies to the arbitration agreement, do you mean that any questions related to the arbitration agreement is governed by the CISG, or are you referring to, and that's the incorporation, consent, substantial validity, formal validity? Which part of the arbitration agreement in your submission is governed by the CISG?
Mr. Arbitrator, when I refer to the applicability of the CISG, I'm only concerned with the substantive validity. The CISG does not apply to the formal validity, as there are lex specialis contained in the national arbitration laws, which concern the form requirements for arbitration agreements. However, there are no lex specialis which are concerned with the conclusion of arbitration agreements, meaning the incorporation or the meeting of the minds. And therefore, the CISG should apply to the conclusion of an arbitration agreement. And in light of these foregoing explanations, I will now turn to the application of the CISG. And there are 2 points which I would like to address. First, the arbitration clause in Article 9 was not validly incorporated into the underlying contract. And second, the parties demonstrated that they had no intent to arbitrate. Turning first to the incorporation. The arbitration clause at issue is not contained in the underlying contract, but in the general conditions of sale, which are a separate document. The conclusion of an arbitration agreement, which is contained in a separate document, requires that the arbitration clause is validly incorporated. Under the Cisg, such an incorporation requires a reference to this clause. Is there a question, Mr. Arbitrator?
Yes. Yes. Would it not be possible for the past practice between the parties to consider that this express consentment to the arbitration clause could be given or stated or as an accepted consent already?
Mr. Arbitrator, the practice which was previously established between claimant and Southern Commodities does not bind respondent, as it is an entire separate entity. And Ms. Bupati, it is not relevant that Ms. Bupati that Ms. Bupati was informed via phone about the content of the arbitration clause when she was still working for Southern Commodities, as she clearly demonstrated towards respondent that she had no knowledge of this clause via her behavior. This is especially evident by her email on page 12, where she was insisting that for respondent, the discussions about arbitration would only be possible if a non-specific arbitration institution was selected. This shows that she was not aware of the fact that claimant had already amended its arbitration clause and already chose a non-industry specific arbitration institution, the Aisc, in 2016. Ms. Bupati was still of the opinion that the arbitration institution by claimant was the Porum institution, which is an industry specific arbitration institution. And moreover, she also raised other concerns about arbitration, namely the transparency issue. Ms. Bupati.
Just, I'd like to go back to the Cisg issue that you are asking that we apply together with the Mediterranean law, because from what I recall from the records, claimant was somewhat confused about the applicability of the Cisg to the merits. Then this issue was clarified, but shouldn't there be a consent from claimant to also apply the Cisg to the arbitration agreement?
Madam Presiding Arbitrator, the Cisg is a part of the national law of Mediterranean, and therefore it automatically applies to contract conclusion issues, and the validity of the arbitration agreement is such an issue of a contract conclusion, as an arbitration agreement is a separate contract.
But just as a follow-up question, but wouldn't it be more natural to understand that Mediterranean law, as far as the arbitration agreement is concerned, is actually addressing Mediterranean arbitration law, or maybe the New York Convention, so a legal framework more specific to arbitration?
Madam Presiding Arbitrator, I see your concern, but the Mediterranean arbitration law or the New York Convention do not contain any provisions about the conclusion of an arbitration agreement, but only writing requirements. And therefore, the conclusion of an arbitration agreement must be governed by the rules which generally apply to contract conclusion, which is the Cisg in the present case. Considering that my time has already progressed, I would briefly address the issue of the formal validity. And the formal validity is determined, as already pointed out by Madam Presiding Arbitrator, by the New York Convention and the Danubian arbitration law. As the New York Convention in Article 2.2 only sets forth an international maximum standard, the pertinent form requirement is the Danubian arbitration law. And under Article 7.6 of the Danubian arbitration law, it requires a valid incorporation for an arbitration clause to be valid as to form, and this arbitration clause was not validly incorporated. Therefore, it is neither valid as to substance nor as to form. Thank you.
Would my co-arbitrators have any further questions to Ms. Hoare?
Right. Thank you.
Okay, so now I'd like to pass the floor to the speaker for claimant in the jurisdictional issues.
Greetings, members of the tribunal. Before I begin my submissions, I would like to just confirm that I am sufficiently audible and visible.
Yes.
Thank you. Members of the tribunal, as I mentioned before, I am Bhavna Lakhina and I represent my client, the claimant, in the present arbitration proceedings. In this arbitration proceedings, members of the tribunal, the respondent is denying the existence of an arbitration clause which it has consented to. And therefore, this arbitral tribunal has jurisdiction to adjudicate upon this dispute based on an arbitration clause that I would be establishing for the next 14 minutes. In order to ascertain the validity of an arbitration agreement, as my opposing counsel has already pointed out, it is important to first determine the applicable law. In the present case, the applicable procedural law should be the Danubian arbitration law. This would be my first limb of the submission. My submission would also concern the CISG's application to the arbitration clause, and finally, with respect to the substantive and formal validity of the arbitration clause. With respect to the applicable procedural law, members of the tribunal, my opposing counsel has relied on the case of Sulla America. However, what she has overlooked is that the Sulla America case has pointed out the reasoning for favoring the substantive choice of law as the implied choice. The court in that case observed that the choice of law, which is the general choice of law, should be extended as the implied choice to determine the validity of the arbitration clause as well, when the parties have an intention to have their entire contractual relationship to be governed by the same legal system. However, this is not the case in the present situation, members of the tribunal. If I may direct the attention of the tribunal to Exhibit C4, which is on page 17 of the record. It is the email sent by Mr. Forrest Rain. In that email, members of the tribunal, Mr. Rain clearly mentions that the sale would be governed by the law of Mediterranean. By the word sale, members of the tribunal, what he meant was that the substantive rights and obligations of the parties arising out of the contract for palm oil should be governed by the law of Mediterranean. As I would also like to quote Professor Bonn in this circumstance, he suggests that when parties choose a general choice of law provision, it is to govern their substantive rights and obligations arising out of their contract, not the procedural aspects which are highlighted in the arbitration clause. Applying the same reasoning, yes, Mr. Rao.
Professor, your mic.
Your mic is muted.
Thank you. Counsel, thank you very much for explaining us in which way this case distinguishes from Sulla America. But I would like to ask you also to appoint us in which aspects this case has similarities with the Sulla America case. Thank you very much.
Mr. President, Mr. Arbitrator, this case is similar with respect to the question of determining the validity of an arbitration agreement and determining the choice of law applicable. However, while pointing out the applicable procedural law, it is also equally important to determine the present case scenario and the particular situations of each case. And even though the question might be similar, however, the reasoning should not be made applicable in the present circumstance. And which is because of the reason that I pointed out, that the claimant intended only the substantive portion of their contract to be governed by the law of Mediterranean. In that circumstance, members of the tribunal, the parties have not made an implied choice in favor of the Mediterranean arbitration law, in which instance it would be reasonable to go into the third limb of the determination of the applicable law, which is the default rule propounded under the Article 5.1a of the New York Convention. It provides that in the absence of any express or implied choice of law, as my opposing counsel has also rightly pointed out, the default rule is to apply the law of the seat. In this circumstance, members of the tribunal, the Danubian arbitration law forms the most appropriate approach to determine the validity of the arbitration clause. My opposing counsel has also...
I think you have two questions lined up for you. I'll start because opposing counsel apparently relied on Article 13.5 of the Aisc rules as a criteria so that this tribunal can decide on the law applicable to the arbitration agreement. So why should we consider Article 5.1a of the New York Convention in this situation? It seems we have a specific rule on this regard.
Madam Arbitrator, the countries which are involved, which is Equatoriana and Mediterranean, follow the conflict of law rules approach, which is provided under Article 5.1a New York Convention, and that is why the New York Convention forms the most appropriate rule that should be made that should be applied to the present situation, and we should apply the conflict of law rules which are provided therein. I presume that there was another question.
It was pretty much the same question, but just framed differently. My question but I think you've answered, but let me just pose it so you can decide if you've ever answered it or not. The New York Convention provides that we should first look to the choice of law that the parties might have agreed upon. And but the parties, would it be wrong for us to decide that this choice is the application of Article 15 of 13.5 letter A of the Aisc rules, meaning that we would then apply the Aisc rules and would have broad discretion? Because the difference that it makes, at least I think, is that if we were to follow Article 5 of the New York Convention, then would be obliged to apply the law of the seat. But if we apply the conflict of law rules of the Aisc rules, then this tribunal would enjoy broad discretion.
Mr. Arbitrator, as I already pointed out, that we should apply the conflict of law rules under Article 5.1a New York Convention, and I hope that does answer your question.
Thank you.
I move to the second submission with respect to the application of the CISG. My opposing counsel suggested that the CISG should be made applicable as a part of the Mediterranean arbitration law. However, members of the tribunal, the CISG provides autonomy to the parties to exclude the application of the CISG. In this respect, it provides that any party can choose to opt out of the application of the CISG under Article 6 of the CISG itself. CISG Advisory Council Opinion number 16 has clarified that the intention to opt out of the CISG for any agreement should be determined according to Article 8 of the CISG. Article 8 has been elaborated upon by Professor Schwenzer, who suggests that the intention of a party should be such that the other party could not have been unaware of that intention. With this, I would request the arbitral tribunal to refer to Exhibit C2 on page 12 of the record, which has the email of Ms. Bhupati. Members of the tribunal, in this email, Ms. Bhupati extensively discusses the terms that the respondent would like to include into the arbitration clause. It is a very detailed information regarding all of the terms that the respondent prefers with respect to the dispute resolution clause to be included in the contract. However, there is no mention of the application of the CISG. Furthermore, members of the tribunal, the CISG being excluded from contracts from arbitration clauses incorporated in contracts of the palm oil industry is a practice that is usually followed by most companies. In such a scenario, it was unreasonable for the respondent to assume that the claimant would automatically construe its intention to have applied the CISG to the arbitration clause. Therefore,
there is a practice not to use the CISG, not to apply the CISG to arbitration agreements in the palm oil industry. I don't think I'm familiar with that information. Would you please direct me to the record?
Indeed, Madam Arbitrator. It is on procedural order 2, the express paragraph which mentions the same is that of just give me a minute, members of the tribunal.
I think we found it.
Would it be clarification number 11?
Yes, members of the tribunal. Clarification 11 provides that the CISG is excluded in the contracts which are used in the palm oil industry.
Mm-hmm.
And since the contract template of the claimant was also based on the FOSFA forum templates, it was reasonable for the claimant to have assumed that the CISG would be excluded from the present contract arbitration clause as well. Since I have already progressed on my time, I would quickly move on to my last submission with respect to the validity of the arbitration clause.
I'm sorry to hold you up, and I'm sure that Madam Presiding Arbitrator will give you extra time should you need. Just one brief point. So do you concede that if the tribunal concludes that your client has not excluded under Article 6 of the CISG its application, then an arbitration agreement would fall within the material scope of the convention's application? So you take issue with the exclusion under Article 6, but not with the applicability of the convention in itself to arbitration agreements. Do I get it right?
Mr. Arbitrator, the position of the claimant is firstly with regard to the fact that the CISG has been excluded. However, if the general practice is with respect to the CISG, it does not govern arbitration clauses in itself. However, since my opposing counsel was focusing on the point that this, with regard to the exclusion of the CISG, it was more relevant to address that issue with regard to the specific point of, with respect to the specific issue that the CISG has not been agreed among parties to be included into the arbitration clause.
I see. Thank you.
With respect to my last submission on validity of the arbitration clause, the opposing counsel has focused on both the substantive validity and the formal validity of the same. I would first address the issue of the formal validity. The formal validity requirements with regard to the Danubian arbitration law is that it is a verbatim adoption of the option, Article 7, Option 1 of the UNCITRAL model law. Members of the tribunal, in this respect, the Danubian arbitration law for a valid inclusion of an arbitration clause requires a reference to the standard terms. It requires a reference to the arbitration clause in a manner so as to make it part of the contract itself. In this respect, the working group in the note of the Secretariat in 2005 has clarified that a general reference to the standard terms to the contract are sufficient to have incorporated an arbitration clause. In this respect, members of the tribunal, in the present contract, which is annexed as Exhibit C2, it provides annexed as annexed as C3, my apologies, on page number 13 of the record. On the very first page, there is a explicit reference to the general conditions of sale. In this respect, members of the tribunal, the formal validity requirements under the Danubian arbitration law are satisfied. With respect to the substantive validity, I may request the tribunal to grant me 1 minute to conclude on my submission with respect to the substantive validity. Thank you. With respect to the substantive validity, members of the tribunal, I would like to refer the tribunal to exhibit C2 again, which is the email of Ms. Bhupati on page number 12 of the record. Therein, on paragraph 6 of this email, members of the tribunal, I quote Ms. Bhupati's email here, that as already indicated at the Palm Oil Summit, the submission of the sales contract to Mediterranean law, which you mentioned as your company's new policy, is less a problem for us than the submission to arbitration, in particular, if we submit to an institution which exclusively deals with palm oil. Her only concern with respect to the inclusion of an arbitration clause was the fact that the arbitration clause should include a non-industry specific arbitration clause, a non-industry specific arbitration rules. In this respect, members of the tribunal, the claimant's arbitration clause is based on the AIAC model and incorporates the AIAC arbitration rules. And thus, there was no other reason for the respondent to have considered the arbitration clause to be contentious and to have not been consented to the application of the arbitration clause. Unless I may be of any further assistance, this marks the end of my submission. Thank you very much.
Council, let me just reset my watch. So would my co-arbitrators have further questions to the speaker claimant? No, so I think we can move on to the rebuttals and surrebuttals, and we start with respondent for jurisdiction, please.
Thank you, Madam Presiding Arbitrator. My opposing counsel pointed out that the general reference to claimant's general conditions was sufficient to also make the arbitration clause part of the contract. Though it is true that such a general reference can be sufficient, this is only the case when both parties have actual knowledge of the content of the arbitration clause. And claimant's arbitration clause was entirely changed, which is evident at first sight. Therefore, Ms. Bhupati had no knowledge since she was only informed in a mere phone call in 2016. Thank you.
Counsel. So now we move to claimant's response. Yes, please.
Members of the tribunal, the fact of the inclusion of an arbitration clause into a contract is one which is very common and often the preferred means of dispute resolution, especially in the palm oil industry. In this respect, even where a commercial party does raise the contention that it did not have notice of the arbitration clause, that is no good reason to not give effect to an otherwise valid arbitration clause. This is majorly because the arbitration clause being present into the contract cannot be anything unforeseeable or surprising to the other party. This marks the end of my surrebuttal. Thank you.
So are we satisfied on the jurisdictional issues?
Yeah.
Yes. So I think it concludes our preliminary discussions. Thank you. And now we move on to the merits. And this time we start with speaker for claimant, please.
Honorable members of the tribunal and esteemed colleagues, my name is Raghav Srinivas, and I will be addressing the merits of this case for the next 14 minutes. In doing so, I will be making two broad submissions. First, that the parties have in fact concluded a valid contract, and second, that the claimant general conditions of sale have been incorporated into this contract. Members of the tribunal, the parties have set up this tribunal at a time where the claimant is willing to sell its excess stock of RSPO certified palm oil and the respondent needs to purchase RSPO certified palm oil. In light of the issues surrounding RSPO certification in 2019, the claimant does understand why the respondent was cautious in proceeding with this contract. However, the claimant fails to comprehend why the respondent terminated all contractual obligations, despite the fact that these issues were rectified a year ago. The respondent now claims that this disengagement was valid because no contractual obligations between the party had formed, which is why the claimant approaches the tribunal today. This brings me to my first submission, that the parties have in fact concluded a valid contract. A contract conclusion pursuant to Article 14 and Article 18 of the CISG requires that there be an offer and an acceptance. Turning to the first element, which is the respondent's offer, the CISG lays down two prongs to determine whether a statement is an offer. First, the offer must be definite enough to determine its minimum contents. And second, that the offerer must have intended to be bound by the offer. Coming to the first prong of minimum contents of the offer, the CISG requires that an offer must be sufficiently definite so that once it is accepted, it can create legally binding obligations. And Article 14 of the CISG has been interpreted to state that these minimum elements include the price of the goods, the quantity of the goods, and the identity of the parties. The offer in the present case can be found on page 12, Exhibit C2 of the record. I invite the tribunal to follow me there. If the tribunal is with me, yes. This exhibit is an email from the respondent's head of contracting, Ms. Bhupati, to the claimant. This clarifies the identity of the parties. Further, if we take a look at paragraph 3 of this email, it reads 20,000 tons. So this would be the quantity of RSPO certified palm oil. This would be the good. And a line below that reads, we have the price of $900 for the first year. The order, in fact, goes beyond these minimum elements and also specifies that the PHOSPHA contract template be used and the CIF trade terms be applied to the present contract. This meets the first requirement, that the offer be sufficiently definite. The second prong of this test requires the intention of the offerer, which is the respondent, to be bound by the contract. The tribunal must determine whether the content of the offer and the conduct of the offerer indicates to the claimant that there existed an intention to be bound by the offer. I now invite the tribunal to take a look at the first element the claimant saw when it received the email, which is again on page 12, which is the subject line. The subject line reads, purchase offer. The purpose of such a subject line is to summarize the content of the email, and the wording purchase offer indicates to the claimant that the head of contracting of respondent indicated to be bound by the offer. Additionally, phrases such as, I would like to place the following order with you, and Ms. Fauconnier will take care of the implementation of the contract, in itself demonstrate an intention to be bound by the contract. With respect to the second prong of the claimant's acceptance by the email of 9th April, Article 18 of the CISG requires that the claimant's intention to be bound by the contract be communicated to the respondent. Once again, this intention must be inferred from the content of the acceptance and the conduct of the claimant. In addition to preparing and signing a contract, the claimant also responded with, on page 17 in Exhibit C4, and I quote here, if the tribunal is with me, great. And I quote here, I have inserted the terms of your offer into the contract, which we accept, end quote. Coming to the conduct of the claimant, once the acceptance was communicated, the claimant stopped its search for other purchasers of palm oil and contacted several shipping companies to get a quotation to transport their palm oil to the respondent. The Australian Supreme Court has held that taking actions in furtherance of previous practice towards dispatching goods indicates an intention to be bound by the contract. Now, at this juncture, the only possible argument the respondent may advance is that the email of 9th April was a counter offer because of the concerns raised by Ms. Bhupati regarding arbitration. However, the reasons for these concerns was because Ms. Bhupati had the claimant's older general conditions of sale in mind. In the old version, there was an arbitration clause with an industry-specific arbitration institution, which was later changed after 2016 to a non-industry specific arbitration institution, which is the AIAC. So the concern was merely that she was fine with arbitration as long as a non-industry specific arbitration institution is selected, and her concern was resolved through the claimant's email of 9th April. Turning to my... Yes,
I'll have a question on this regard. Oh, Professor, if you want to go first.
No, you go first.
Okay, thank you. My question would be, Ms. Bhupati's email shows that she was clearly confused about the arbitration agreement wording. So shouldn't claimant have clarified something? Because it seems that, at least at the eyes of respondent, it seemed to be an alteration that they were asking to be made, yes.
Madam Arbitrator, it is our submission that the claimant did in fact clarify the contents of the general conditions of sale. If I may refer the tribunal to Exhibit C4.
Which page, please?
Exhibit C4 on page number 17.
Oh, it's the same. Okay.
We're
there.
Mr. Chandra asked me to point out that in deviation from our previous practice established between Ms. Bhupati and Chandra, the sale will be governed by the law of Mediterranean. This was pointed out by the claimant during the palm oil negotiations and was further reiterated in the email itself. So Ms. Bhupati was in fact aware of the contents of the general conditions of sale. Does that answer your question?
Professor José Gabriel has a question.
Thank you very much. Counsel, just one point. I would like to hear your opinion. When we are dealing with general conditions in a situation like this, isn't there a higher standard that should be followed by the arbitral tribunal when appreciating the consent of the parties to the agreement?
Mr. Arbitrator, the standard that the tribunal must apply in such a situation is whether the contents of the general conditions were made available to Mrs. Bhupati. The question of whether or not Ms. Bhupati read the contents of the general condition lies in the negligence of Ms. Bhupati herself. Yes, Mr.
So, Counsel, you are saying that as long as the general conditions were made available, consent should be presumed.
Yes, Mr. Arbitrator. We say that as long as it was made available and Ms. Bhupati did have a reasonable opportunity to take notice of this content, consent should be assumed. This was noted in the tantalum powders case before an arbitral tribunal.
Thank you very much.
Turning to my second submission regarding the claimant's general conditions of sale, they must be incorporated into this contract for two reasons. First, the general conditions have been expressly referenced. And second, they do not come as a surprising term to respondent as they were aware of its content. Coming to the first reason of reference, Professor Berger notes that the general conditions of sale can be incorporated into a contract as long as the other party has had a reasonable opportunity to obtain the general conditions of sale. This can come either through a reference to the general conditions in the contract itself or being made available on the other party's website. In addition to referencing the claimant's general conditions during the negotiations and also twice in the contract itself, The claimant have also referenced the applicability of the general conditions in a separate email along with claimant's acceptance on the email of 9th April. Additionally, these general conditions are also available on the claimant's website. Considering the fact that Mrs. Bhupati has been interacting with the claimant for over 10 years now, she must have had access to this website. Since the respondent never requested for clarifications about the general conditions during the 6-month period between the conclusion of the contract and its termination, it is clear that they did in fact have a reasonable opportunity to obtain the general conditions of sale at any of these points. Addressing the second reason of surprising term and respondent being aware, several arbitral tribunals have evolved a 2-pronged test to determine whether the general conditions of sale come as a surprising term. First, whether the other party was aware of its content, and second, whether they could understand the language and presentation of the general conditions. These general conditions do not come as a surprise to respondents since both these prongs have been satisfied. Coming to the first prong of the respondent being aware, a standard term is not surprising as long as it is reasonable to expect for the other party. The reasonability of a term is determined by the practice in the trade industry. Mrs. Bhupati was informed that the claimant would be using the exact same general conditions which she had access to when she worked at Southern Commodities. Additionally, the respondent cannot argue that the term comes as a surprise, since it was they who requested that disputes be submitted to a non-palm oil specific institution, which was exactly what the general conditions also reflected. Additionally, the claimant general conditions has an arbitration clause, a termination clause, and a sampling and analysis clause. These are the most commonplace standard terms of contracts in the palm oil industry. For instance, general conditions by companies such as Unilever or Muslim Mas, which are palm oil suppliers, have the exact same terms. Thus, the respondent was in fact aware of the claimant's general conditions of sale. With respect to the last prong of language and presentation, the Mediterranean law requires that the general conditions not be obscure. This requires that the general conditions be in a language that is understandable and easy to follow. In the present case, the claimant's general conditions were written in English, which was the language the parties have used throughout the negotiation, and their reference was presented on the first page of the contract itself. The metal slabs for construction purposes case has held that general conditions become obscure only if they're presented at the back of the contract. Thus, they cannot come as a surprise to the respondent. Seeing that my time is running out, I would like to quickly conclude by requesting the tribunal to hold that the contract has been validly concluded. And if the respondent really does care about the environment as much as they claim, we believe that they will see eye to eye on the fact that close to 20,000 tons of perfectly good RSPO certified palm oil must not go to waste.
Thank you. Would my colleagues have further questions for this speaker in particular?
No.
No, so thank you. Let me reset my watch. I believe we now can move on to the speaker for merits on respondent's part, please.
Thank you, Madam Presiding Arbitrator. Honorable members of this tribunal, esteemed colleagues, good afternoon from Cologne. My name is Joel Ola, and I'm presenting the merits of the case on behalf of respondent. As correctly stated by opposing counsel, a contract is generally concluded through an offer followed by an acceptance after some negotiations between the parties. This requires that the parties are on the same page regarding both the terms of the contract and whether they even want a contract at all. However, contrary to claimant's allegations, no contract was concluded as these prerequisites have not been met. Rather, after losing its largest customer due to being at the center of a massive greenwashing scandal, it is claimant who is in need of selling off its palm oil surplus. As a consequence, it is trying to force our client to perform a contract it never entered into. In addition, claimant is trying to incorporate general conditions of sale into the contract, which are not only completely unknown to respondent, but even contradict the concerns mentioned by our client. In light of this, I would like to make two submissions. First, claimant and respondent never concluded a contract. Second, even if the parties did conclude a contract, it did not incorporate claimant's general conditions of sale. Turning to my first submission, I will demonstrate that, contrary to the allegations of opposing counsel, the email Ms. Bupati sent on April 1st did not constitute an offer, and that the contract was not concluded. I will demonstrate this with three arguments. First, the offer Ms. Bupati sent on April 1st did not constitute the email she sent on April 1st did not constitute an offer. Second, the email Mr. Chandra's assistant sent on April 9th did not constitute an acceptance, but merely a counteroffer. Third, this counteroffer was never accepted by our client. Turning to my first argument, the email respondent sent on April 1st did not constitute an offer. Respondent acknowledges that the opposing counsel's allegation that the email set out the commercial terms of the contract. However, it did not. The respondent did not intend to be bound until there was an agreement on the arbitration agreement. This was as it deemed the arbitration agreement to be of particular importance. A similar decision was found in the Cologne case, but the U.S. District Court for the Southern District of New York in 2011. There, the court ruled that the parties only intended to be bound until there was an agreement on a term they deemed to be of particular importance. These terms were, in that case, the choice of law and the dispute resolution clauses. The situation in the present case is quite similar, as the parties deemed the dispute resolution mechanism to be of particular importance. This is evident from both their conversations and their correspondence. Would the arbitral tribunal please turn to page 10 of the record? Is the tribunal with me? In the middle of paragraph 11 of Mr. Chandra's testimony, you can see that the parties already discussed their different views on arbitration. I quote, "She, meaning Ms. Bupati, indicated, however, that it could eventually be necessary to adapt some of the legal terms which had been used in the previous contracts between us, in particular, the dispute resolution mechanism, given the widespread hostility to arbitration in Equatoriana. This shows that respondent was heavily concerned with going to arbitration. In contrast, Mr. Chandra said the following for claimant. I quote, "I told her that for us agreeing on anything but arbitration would be very difficult. This shows that the submission to arbitration was of particular importance for claimant. Therefore, both parties deemed the dispute resolution mechanism to be of particular importance and only intended to be bound until there was an agreement thereupon." Ms. Bupati then referred to these concerns again in her email, demonstrating that arbitration was still a serious concern for our client. She even specified these concerns in her email. Would the arbitral tribunal please turn to page 12 of the record? Is the tribunal with me? In the second to last paragraph, which starts with, "You probably are aware," she says in the last sentence, and I quote, "At least we should select a non-industry related arbitration institution and provide for some sort of transparency." This shows that that claimant's allegation that Ms. Bupati's only concern was the industry-specific arbitration institution cannot be upheld, as Ms. Bupati specifically said that transparency was also a major concern. Consequently, respondent would not...
I'm so sorry, if I may briefly interrupt you there. So your submission is that the claimant's exhibit C2 does not constitute an offer because, and please correct me if I get you wrong, because some points were still subject to negotiations. But we cannot deviate from the fact that Ms. Bupati herself said that it was a purchase offer. And my question is, had the opposing party just said yes and drafted the contract as requested with the unsubscribed transparency rules and all other details, wouldn't that have been? My question is, how can you say that that was not an offer? I understand at some points she was concerned, but I'm not sure if I'm making myself clear.
Can I make a follow-up? because it seems to me that the requirements for the offer are set out at the Cisg. So I understand that council brought a case law in which the same view you are arguing was adopted, but would there be any other elements? I believe this is in line with Professor Grunbaum's question.
Members of the tribunal, it is true that Ms. Bupati started the email off with saying purchase offer. However, it is not only the wording of an email, which is, or the wording of a statement, which leads to the interpretation whether it is an offer and has an intent to be bound. Pursuant to Article 8.3 Cisg, it is also the surrounding circumstances which are relevant to determine whether there was an intent to be bound. As Ms. Bupati indicated that she was still majorly concerned with arbitration, she only intended to be bound until there was an agreement thereupon. However, I see your concern, Mr. Arbitrator. What would have happened if claimant provided for the application of the unsettled transparency rules and the non-industry specific arbitration institution? Ms. Bupati also stated that she wanted the contractual documents to be prepared for signature. This demonstrates that, as Article 14 CSG sets forth, an intent to be bound must be, I quote, in a case of an acceptance. This shows that Ms. Bupati only wanted to obtain the contractual documents first and then accept them with her signature. This shows that the email only constituted an invitatio to contract and not an offer. However, even if the arbitral tribunal decided that this email did in fact constitute an offer, the email Ms. Chandra's assistant sent on April 9th constituted at most a counteroffer and no acceptance. As per Article 19.1 CISG, a statement which purports to be an acceptance is deemed merely a counteroffer if it materially changes the terms of the offer. Pursuant to Article 19.3 CISG, such material changes may be terms relating to the dispute resolution mechanism. In the present case, as you can see on page 17 of the record, and has been pointed out by opposing counsel, claimant tried to incorporate its general conditions of sale, including an arbitration clause. While this was, as shown by my co-counsel, not sufficient to conclude an arbitration agreement, this was also not sufficient to incorporate the general conditions of sale, as I will show later on. However, claimant only intended to be bound by these terms, which were in conflict with Ms. Bupati's concerns, as claimant did not address Ms. Bupati's concerns regarding transparency in the possible arbitrational proceedings.
So, just one minor clarification of fact. Maybe you can assist me with that. Ms. Bupati asked for the adoption of the Phosphapora model contract. Would you know if the Phosphapora model contract would already contain an arbitration agreement?
Mr. Arbitrator, in general, the Phosphapora model contract does contain an arbitration clause for an industry-specific arbitration institution, which is that of the Phosphorum institution. However, claimant had always used a modified template of this, which we can also see in her email, as she said, I quote from paragraph 5 of page 12, I assume the documents for the sale of palm oil are largely comparable to those for the sale of kernel oil and are based on your shortened version of the Phosphapora model contract. That shortened version of claimant did not contain an arbitration clause, which was only contained in claimant's general conditions of sale. Therefore, Ms. Bupati's reference to the model clause, model contract did not include a reference to an arbitration clause. And turning back to my argument, Ms. Bupati's concern regarding the transparency in the proceedings was never addressed by claimant. In contrast, claimant chose the AISC as the arbitration institution, which provides for confidentiality of the proceedings in Rule 44 of the Aisc rules. Consequently, the terms would be materially different, and the email constituted at most a counteroffer. This counteroffer, however, was never accepted by our client. To conclude, the parties did not conclude a contract on the sale of RSPO certified palm oil. Coming to my second submission, contrary to the allegations of opposing counsel, claimant's general conditions of sale would not have been incorporated should there have been a contract. Under the CISG, the incorporation of general conditions requires first a clear reference, and second, that they were known by or made available to the offeree. These requirements have been adopted by courts of various jurisdictions, such as the German Federal Supreme Court in the machinery case, and even the CISG Advisory Council. Turning to the reference must be so clear that the offeree could not be unaware of the offerer's intent to incorporate the general conditions of sale. Respondent acknowledges opposing counsel's statement. The general conditions of sale were referenced at the summit and in the contractual documents, and in the email dated April 9th and the contractual documents. However, in the present case, this reference was not sufficient as respondent neither had knowledge of the general conditions, nor were the terms made available to our client. As already shown by my first, the opposing counsel stated, and I quote, Ms. Bupati had the old arbitration clause in mind. This already shows that opposing counsel admitted that Ms. Bupati, at the time of contract conclusion, was confused about which was the current arbitration clause and therefore had no knowledge of the arbitration clause. In addition, all of the other provisions were also unknown. Opposing counsel also alleged that, as Mr. Rain pointed out the applicable law, Ms. Bupati had knowledge of the general conditions of sale. It is true that Ms. Bupati had knowledge of the choice of law. However, this does not mean that she knew any of the other clauses in the general conditions of sale. Therefore, respondent did not have any knowledge of the general conditions, and claimant would have had to make its GCOs available to respondent. However, this was never the case. They were not made available during the negotiations, and in particular, they were never sent to our client. Opposing counsel stated that the general conditions of sale were made available on the website. However, I would like to point the arbitral tribunal to page 50 of the record. Is the tribunal with me? In para 18 of the procedure order number 2, in the last sentence, you will see that the general conditions of sale are also not easily accessible on claimant's website. This shows that respondent could not have become aware of the content of the general conditions of sale from claimant's website, as they were not easily accessible there.
Also, I would have a question, because it seems to me that the correspondence from claimant to respondent made it clear that the general conditions would apply. So shouldn't respondent have been more proactive and asked for this document, which was referenced in the emails and the contract and so on?
Madam Presiding Arbitrator, multiple courts, including the German Federal Supreme Court, have ruled that, first of all, as I see my time has already progressed, may I ask for an additional minute to answer a question and then conclude my submission? Thank you. Multiple courts, including the German Supreme Court, have ruled that general conditions of sale need to be made available to the offeree. However, there is no duty to inquire on the content of the general conditions of sale by the offeree. This has also been confirmed by the CISG Advisory Council in its opinion number 13. I quote from comment 2.8. It should not be incumbent on the offeree to request a copy of the standard terms from the other party where the latter seeks to incorporate the standard terms. Therefore, there is under the CISG no duty to ask for a copy of the general conditions of sale if they were referenced. In contrast, it is the duty to inform the offeree of the content of the general conditions is placed on the offeror, in the present case on claimant. As claimant did not fulfill its duty, the claimant's general conditions of sale were not incorporated into this contract. To conclude, respondent respectfully seeks the arbitral tribunal to find that first, the parties did not conclude a contract, and second, should a contract have been concluded, it did not incorporate claimant's general conditions of sale. Thank you.
Thank you, counsel. Do we have further questions on respondent for merits?
No.
No? Okay, so I think we can now go back to counsel for claimant for the rebuttal, please.
Mr. Chandra had noted during the palm oil summit, and I quote, I told her that for us, agreeing on anything but arbitration would be very difficult. This was made on 29th March, to which Ms. Bhupati claimed that she would have to get confirmation from respondent's management and get back to claimant in 3 days. After 3 days of extensive deliberation with the respondent management, on 1st April, Ms. Bhupati sent an email titled Purchase Offer, which clearly indicates that they accepted the claimant's terms, and which both indicates an intention to be bound, and also that claimant's email on 9th April, which included an arbitration clause, was not a counter offer because it never materially altered the content of the negotiations. Thank you.
Counsel, now please, counsel for respondent to may answer.
Thank you, Madam Presiding Arbitrator. It is true that Mr. Chandra pointed out at the summit that anything but arbitration would be very difficult for claimant. It is also true that Ms. Bhupati had talked with the management. However, in the following email, as you pointed out, Ms. Bhupati also stated that, that she was still concerned with going to arbitration, in particular with the transparency, with providing a mechanism for transparency. However, claimant never addressed these concerns for transparency, and therefore respondent's minimum condition to even continue the negotiations on arbitration were not met. Thank you.
Counsel, so are we satisfied with the discussions on the merits of the case?
Yes.
So great, so thank you. I believe that concludes our hearing. Are the parties satisfied by the way they were treated in this hearing?
Yes.
Okay, so thank you. Now, since we are live streaming this event, we are doing our best efforts to be as quick as we can with our deliberations, even though we have a very difficult task ahead of us. So our commitment to the speakers and to the audience is that we are going to take at least 5 minutes. So you have 5 minutes should you need a little break. We arbitrators are going to turn off our cameras and deliberate in private. And so the audience and the speakers, you have at least 5 minutes break before we come back with our decision. Thank you.
Thank you.
Thank you very much for the pleading. We really enjoyed it with you guys.
Thank you. It was a lot of fun.
Yeah, we
It's
really
an
enjoyed
equal
it.
pleasure for us.
Thank you.
So, okay, we are back. At this stage of the competition, of course, both teams were excellent. It was no surprise for us. So I congratulate both teams, not only the speakers, but the entire team coaches and other colleagues that I'm sure for the past months assisted you and helped you get to the level you are here today. We had a difficult decision, but however, it was an unanimous decision. And the prevailing team for this round was the University of Cologne. Okay, so congratulations.
Thank you very much.
Thank you very much.
Later on, we will wait for the results of the other quarterfinal rounds, and then we'll provide to you the pairings for the semifinal rounds. But thank you all. Thank you also for the audience to being here with us, and congratulations to both teams. We are sure you'll do excellent in the competitions that come ahead of us. Congratulations. And also thanks to my colleagues, Daniel Burambal and José Gabriel Cisg Almeida.
Thank you.
Thank you very much.
It's the awkward moment that we're still alive, and I will ask whether we're still alive, and probably we are. Okay.